This is Tim from Sheridans, and he is joining us today just to kind of give that 101 into freelancer contracts. Obviously, so many people in the games industry works that way. So I will leave and hand over to Tim. Any questions in the chat, and we will do Q&A at the end. So take it away, and I will jump off.
Perfect. Thank you so much, Lucy, and thanks everyone for joining today. It's a real pleasure and an honour to be here for the Women in Games Global Conference. As Lucy mentioned, my name's Tim. I'm a games lawyer at Sheridans, and I've also got the great pleasure of being a trustee for Safe in Our World, who's also has a booth at the as part of the expo today. So if you haven't been along to there, please do pop along. We're doing some great stuff, trying to raise awareness for mental health and mental illnesses in games. Trying to support games industry professionals and also the wider industry, including players who play our games. So, as Lucy mentioned, we're going to look a bit about freelancer contracts. But before we do that, I just wanted to give a little bit of information about Sheridans. So we started as a music firm back in the 50s, and we still do act for like legacy acts like Led Zeppelin and Pink Floyd. But over a decade ago now, must be nearly 20 years, we started advising developers, and we're very much known as like a developer focused firm, although we do act for some independent kind of indie publishers. We are very much a developer focused firm, and we advise independent studios from single person teams all the way up to AAA, including some of the names there. And also, as I mentioned, I want to give another shout out and another plug to Safe in Our World as I'm a trustee. Please do go check out the expo if you haven't done already. And yeah, we're really trying to do some great stuff. We've nearly been, the charity is coming up to its first anniversary. It was founded by Leo and Neil over at Y Productions, with the aim of trying to make the games industry a more inclusive, more aware space, and to support people with mental illnesses, both within the industry and the wider industry too. So looking into, and I've lost my slide. So looking into freelancer contracts. So as Lucy mentioned, freelancers are very much the lifeblood of the industry. We work with a lot of creatives, individuals that work on projects, and obviously, studios that are looking to engage freelancers to work on their game. Especially at the independent level, it's very rare for a whole studio to have the complete set of skills that's necessary. That's why freelancers are great, because you can plug a gap here or there, across a wide range of skills that are necessary to make a game and bring it to market. So a few of the things that I wanted to look at, and we'll try and do it, or at least try and look at the balance about what you should be looking for if you're the studio, what you should be looking for if you're the freelancer yourself. That will include stuff like IP, making sure that you get paid, or how not to pay if something's not quite right, how to get out of a contract if it's not working out for either side. And then we'll finish with a little bit about revenue sharing, because I've definitely done quite a few deals more recently where that seems to be becoming more prevalent, especially for indies where maybe cash up front isn't an option. So offering a revenue share to a freelancer might be something you want to consider. So what is a freelancer contract? I mean, kind of an obvious question, I guess. This is the kind of thing where it's deemed work for hire in the US. We very much adopted that terminology over here. So it's obviously between a developer and a contributor to that game. And it will usually include a list of services, payment, etc. Most of the things we see are for external musicians, but obviously it's artists, programmers, everything that goes into games that freelancers do for a studio. I've got there that they should be in writing, and that comes to an intellectual property point that we're going to talk about a bit later. But the reason why it should be in writing is because if you're a studio and you're looking to engage a freelancer, the rule of authorship around copyright, which is a form of IP in the UK, but this is the same rule in the US as well, is that the intellectual property, whatever that freelancer is making for your studio, will continue to be owned by them until or unless there is a written agreement to the contrary. Now, that is the case even if you are paying them or you've paid them any sort of money. It doesn't matter. That is what the rule is. Now, there's different things. You might be able to imply that you have a license to use whatever they have done in your game, but to avoid any headaches, it's better for both sides, I'd argue, to have something in writing so that it is clear what's expected about both sides and what is happening with IP and whatever the freelancer is making for your game. So my next sort of slide, I've listed kind of the top things that will come up in all of these or most of these contracts like this. And I've got IP at the top there, again, very much for the reason that I just stated. The usual position would be for a studio in that if you're engaging a freelancer on your game, the base position will be you will probably want everything, or you want to own all of the IP in what the freelancer is doing for your project. At the end of the day, it is your project. But there are some slight exceptions to this, and from a freelancer perspective, it's quite, you should be aware that if you do have your own, proprietary tools or technology or code libraries, specifically if you're a programmer or freelance programmer, you should definitely carve those out from any assignment of intellectual property so that you can use these tools, again and again for your next project. Now, what will happen there is the studio, you will rightly want to have access to those tools, if they form part of, whatever is being delivered to you by the freelancer. But you won't need a full assignment to use them or even exclusive license to use them. What position would happen there is you would expect a non-exclusive license to use those proprietary tools belonging to the freelancer. Making sure that is in there will just avoid any headaches down the line. No one wants to have a copyright strike because, if you fall out with a freelancer and it turns out that you haven't licensed the tech or you don't have that in there, it just pays to have that in writing and be really clear for both sides. What's being assigned? If it's not being assigned, is it being licensed? And then if it's being licensed, is that license exclusive or non-exclusive? And I'll talk a little bit on the next slide or a couple of slides down about an exception to that rule, which is very much musicians and composers, and I'll come on to that in a bit more detail. So I've got payment and I've also got revenue share in brackets there. So obviously, if you're a freelancer working on a project, you want to know how you're going to get paid. And same if you're the studio, you want to know, when are you paying this person, and how often are you paying them? Are you paying them on delivery? Are you paying them just on a monthly kind of retainer basis? It's in the interest of both sides that is kind of very clear and very upfront. For a studio, it isn't uncommon to want to only pay, on delivery once you've approved the milestones or the works or whatever is being delivered to you. And from a freelancer perspective, that isn't an unreasonable request either, but there has to be a balance in terms of if you're a freelancer, you want to make sure that approval isn't withheld or delayed. So what would usually happen is that you'd put a time period in the contract that says the studio would have to review and approve or give you feedback within a certain amount of time, probably 7 to 14 days. If it's a bigger project, it might be up to 30 days. But the general feeling being, if they haven't given you any feedback or approved the milestone within that time, the default position would be that it is approved for the purposes of payment, and then you would be able to put your invoice in. On a freelancer basis, if you're a contributor, you just don't want to be going hand to mouth. You don't want to have invoices not paid because there's just open-ended deadlines in terms of when people can review or approve that work. So that's an easy way of kind of getting around that. Obviously, if you're getting paid monthly, that whole problem sort of goes away and you're just kind of doing work a lot more flexibly. So it can really work depending on the studio and depending on the freelancer and depending on how you work already. The scope of work, obviously a little bit obvious, but if you're the freelancer, you need to know what you're doing. And also for the studio, you sort of want to, you also want to kind of know what the freelancer is doing for you so that if there is an approval mechanism that's linked to payment, you would want to check that they have actually delivered what they said they would deliver, so that you can either determine whether what they've done is correct or not. Ditto for the freelancer, if you've got a clear scope of work and the studio might be being a bit of a pain in paying you can at least then point to that and say, well, this is what we said. This is what I said I would deliver by this date. I've done that. Therefore, I should be getting paid. There's a tendency from the studio perspective to keep things quite vague, and if you want to work flexibly, that's fine. Scope, you don't have to set a full scope of work at the start of a project, and often that might not be possible. It's perfectly reasonable for a scope to be updated from month to month or after a deliverable has been delivered. For both sides, and for the sake of both sides, I'd say the big caveat is that any changes or any updates to the scope should be agreed by both sides in writing. And that can include email. It doesn't have to require a whole written agreement. It could be Slack, it could be Trello or Skype, any sort of application where there's a paper trail and you can go back and check what has been agreed is useful. So reps, warranties and indemnities, these are kind of the very much the legal bluster of every contract. Effectively, they're the legal promises that each side is making to the other about the work that they're doing. For the studio, the most obvious, and also for the freelancer, the most common ones that you are going to see are that a studio is going to ask a freelancer that everything that they do for them on a project is original and is their own work. It isn't copied from somewhere else, and that it won't infringe any intellectual property rights of a third party. They're all fairly standard things to give, and it's to be expected, because ultimately, if that studio has an agreement with the publisher, they would have provided those exact same reps and warranties to the publisher or the financier, whoever is funding their game. So it's not unreasonable to ask that you haven't copied something and it's your own original work. Things to be, I guess, careful of from the freelancer point of view is how hard is the standard that they're putting on you in terms of quality of work. From a studio perspective, you obviously want them to do a reasonable job. You want people to exercise with reasonable skill and care. And from a freelancer perspective, that's probably fine as well. But this section can often get really glossed over. And sometimes it can be too brief, sometimes it can be too long. And it's usually quite technical, especially if, we lawyers, we like to use big words. We like to make things a little bit more confusing. So if you're reading something you don't understand it, I think always feel free to seek legal advice. Most lawyers in the games industry, myself included, will have no obligation consultations where you can come and just ask a question, for an hour. We'll have a call or, something over Slack, and we're happy to answer questions. So feel like if there's something there that you're not quite sure you understand, then it's always worth raising that point with someone before you sign the contract. Termination. So obviously, if stuff's not working out, you want to be able to get out of it. For a studio, obviously the obvious kind of termination would be, on breach, or if someone's in breach. But for most cases, on a studio and a freelancer basis, you'd probably want a mutual right to terminate or walk away on giving a specified notice period, probably 28, 30 days, something like that, whereby both sides can just say, look, this isn't working out. We mutually terminate, but you'll continue to work for that notice period, and we'll continue to pay you for the work during that time. Very much like an employment contract, albeit with a much shorter notice period. It's also not uncommon to put a probation period in there, especially if you're working with someone for the first time. So similar to an employment contract, again, it would just be involved a smaller period. You might have a period of 3 months where in that time the notice period for termination is shorter. So rather than 30 days, you're probably looking at 14 days or something like that, where it just allows both sides to test the relationship. If it's not working out, both sides can walk away. And there's other kind of forms of termination that usually will appear on breach. So if one side is in breach, it allows the other side to enforce the contract. It usually involves someone like me getting involved to help with that. But from the freelancer perspective, that's going to be if you aren't being paid when you're supposed to have been paid. From the studio perspective, that's going to be a freelancer not delivering what they said they would deliver, or it not being very good quality. Again, there'll usually be a notice period involved in that, but it will usually be shorter. And both sides, whoever is in breach, will usually be given an opportunity to cure that breach, because late payments happen. There can be errors with the bank that mean that money hasn't got processed in time, invoices get lost. And ditto for a freelancer, sometimes a deadline might be missed and it's not their fault. So usually a cure period of 7 to 14 days is also reasonable to allow the person who's in the wrong to put right whatever is wrong. Confidentiality. Now, you might have signed an NDA with this person up front, in which case, great, and you can obviously always incorporate those provisions into your freelancer agreement. But usually you will see a standard or standalone confidentiality provision in those agreements as well. They don't need to be particularly complex. Obviously, all that needs to do is protect. You don't want anyone disclosing the terms of the contract or the terms of the project that the freelancer or the studio is working on, especially if the project hasn't been announced or released yet. You want to keep those things under wraps. And it's usual for this sort of provision to be mutual, so it will apply to both the studio and the freelancer. And I've got a non-compete provision there, and this is very much an optional thing, but it depends on how essential, I guess, the freelancer is to your business, or if you're a freelancer studio and maybe you employ multiple people and you're an outsourcing studio and you're engaged by someone else. You don't necessarily want studios poaching your staff either, so it could be a non-compete in terms of the game that you're doing. But I think it ties also into kind of like non-solicitation of staff, and maybe non-disparagement as well, especially if a relationship hasn't ended particularly well. You kind of just want, both sides might just want to walk away and there not to be any negative press about it. So there's a whole bunch of kind of like optional clauses that you can add into these agreements, that take effect post termination. But a non-compete is usually a fair one, especially for a freelancer who's been maybe deeply embedded in a studio. You don't necessarily want them producing something that's similar to the game that they've been working on for you, and adding in a restriction for a certain number of months after they've left your commission is a reasonable thing to ask for. So I've got here musicians and composers are kind of the exception to the IP buyout rule. Now, I kind of skimmed over what happens with IP, but the general position, as I mentioned, was for studios, when you're engaging a freelancer, the general position is you probably want to own outright. You want to buy out all of the IP that the freelancer is creating for you, potentially excluding that freelancer's bespoke tools and tech. But generally, everything that they're doing for you that's specific to your game, you will want to have a buyout of rights for that. Now, what we're seeing in the market for musicians and composers is a little bit different, and actually the exception to that rule is that, especially a lot on the independent developer side, a lot of musicians and composers want to retain the rights to the music. Now, generally, speaking, I say that's fine, and there's advantages to doing that in terms of a composer or musician probably already has loads of channels set up in which they can distribute the music. They probably have accounts with Bandcamp, or they might have contacts with Spotify where they can put a soundtrack up relatively quickly and start monetizing it. And that can have a cyclical effect in terms of, game music is so popular now, in that it can drive people to the game, the game drives people to the music, and you can have a mutually beneficial relationship in doing that. Now, what needs to happen in terms of the IP and the soundtrack that they're making is that if it's specific to your game and it's an original soundtrack, you obviously want exclusive license, you want exclusive rights to use that in your game and any promotional materials. And you don't want the composer to be, be allowed to use it in other games. So it kind of diminishes the originality of what they've created for you. So that would be called an exclusive license. And it gives you the exclusive rights to use the soundtrack in your game and any marketing and any other sort of media, really, aside from selling it as a standalone product. And that's usually where the carve-out will be, where it's exclusive to the studio, but the freelancer's rights are limited to it, allowing it to distribute the soundtrack on a standalone basis via various channels. And you can usually name the channels, and it's the old favorites, Spotify, Apple Music, Amazon Music, Bandcamp, SoundCloud. And that's just something we're seeing a lot more of now in terms of musicians want to retain the rights to that. And as I said, it's fine to do so, but as a studio, as a developer, make sure you have the rights to use that music in your game. If they're selling it if the composer is going to sell it as a standalone product or make it available as a standalone product, it should be clear that it's the original soundtrack to your game, so you can have that cyclical effect where the music drives people to the game, and you get that kind of, the game drives people to the music, and you have that effect, that mutually beneficial effect. So the next slide here, and now I don't know if people have come across do contract, but I thought I would just throw my 2 cents on this anyway, because I've come across it quite a few times in the last few years, but not always on a positive basis. So do contract, for people that don't know, is an online resource. It's free, that it's available, and it's basically an online contract or agreement. You can plug in the commercial details that you want, so you plug in the party names, plug in the amounts, plug in the dates, plug in the fees, and it will produce a contract for you, and it's ready to go, within minutes. And it is, from that perspective, I think it is great. Where it falls down, though, in my opinion, is in terms of the termination provisions and being allowed to walk away. Now, the big fallacy with the contract itself, I'd say, is that it likes to suggest that we're all going to be friends forever, and that an agreement can be mutually worked out between a studio or a freelancer in respect of a game. Now, I hate to be the bearer of bad news, and I hate to be a bit of a downer, but that simply isn't the case. Sometimes relationships do get damaged beyond repair, and trying to come to a mutually agreeable conclusion before a contract gets terminated just isn't going to happen. That's why when I was talking about the termination provisions earlier, I was saying that, it's better just for both sides to have a right to end the contract within a certain number of days, because it's unlikely you'll be able to agree things mutually. And also, if someone is in breach, you probably aren't going to come to a mutual agreement that the other person is in breach, especially if they're the breaching party. That's how disputes arise, and it's unlikely that they're going to be resolved amicably in that case. So on that basis, I'd say if you're going to use do contract, fine. I would always say please do get it checked over by a lawyer first, because for sure they want to make changes from it. And I think just don't kid yourself in terms of a free contract being a great resource. It is a decent resource, but I guess I'm in a job for a reason in terms of hate to be the bearer of bad news, but we're not all bad and we're not all expensive. So if you do have questions, I think on those, please do put things in front of a lawyer if you just need something to get a sense check. I realize I'm running out of time. We've got 5 minutes, but I'm going to quickly gloss through revenue sharing, because we're seeing a lot more of these sorts of arrangements happening for independents, especially the smaller independent studios. So obviously this is sharing revenues from game sales, or profit sharing is what it's always also called, or royalty shares. Three different phrases for the same thing, effectively. And they can be great, especially for indies, when you don't have the cash up front and you want to keep a freelancer involved for the project for the long term. You probably can't pay them their full rate up front, so you give them a bit more skin in the game, and they get, you should effectively going to share profits on the game if it does well. Then the freelancer is going to be rightly rewarded for that success as well. So issues that can come up with royalty share, revenue share arrangements is that, if they aren't specific enough, it can really get messy. And when I say specific, when we're talking about revenue share, well, exactly what are we sharing? Is it gross revenue that's being received, before deductions, or is it net? If it's net, then what are you deducting before money is getting paid out? As the studio, you might have incurred more costs. Are you allowed to recoup those costs beforehand? If, exactly what are those costs? How much are you allowed to recoup before that money gets paid out? So those things need to be explicitly clear. And also, I put platforms in there, because if it's, if you're working with a porting house or an individual that's helping you with a port, I presume, maybe you just want to limit their revenue share specifically to the platform that they're working on, not necessarily the PC version if they're just working on Switch. So again, it needs to be clear where the money is coming from and which platform is paying you, and therefore, where that revenue will get split to. And I've also got revenue shares can also be, well, sales or contributions. So obviously it can be a share of the sales or the money that you receive from selling your game. But you can also, base it on, the percentage can also be based on, however much the freelancer has contributed to your game. And that percentage can go up if they've done more. It can remain low if they've done less. I've seen an interesting model recently where a studio paid a freelancer and that the revenue share went up as long as they were with the game when they passed certain milestones. So that was, past green light, past alpha, past beta, past first playable kind of thing. And all of those kind of models can work out really well. So final thing, so again, being specific, so who's collecting and who's exploiting? If you are the freelancer in this situation, it's probably going to be the studio that's going to be collecting and exploiting. And what is the split? I talked about that's just going to be the percentage. But from a freelancer perspective, if the studio is collecting, you need to know when they're collecting, how they're going to pay you, what time they're going to pay you. Are they going to give you a report about how much revenue is received? Are they going to give you details of the deductions they're making before they then pay your revenue share? Again, all these things need to be as specific as possible and clear as possible. But they don't necessarily need to be overly complicated. But again, that's sort of why I'm here, in terms of lots of lawyers in the games industry can help guide you through this whole process. And again, I've got termination in here as well, because again, these arrangements can get messy. And again, if a contract doesn't have a clear termination provision, you might be on the hook for paying a revenue share to a freelancer, even if they've been in breach. So it needs to be clear that if someone is in breach, that probably waives the revenue share. But if it's the studio that's in breach as a freelancer, you obviously don't want that to happen. You want them to remain on the hook to pay you, even if they're in breach, or even if they walk away, because that isn't your fault. And I've got non-disparagement provisions in there as well, because these things can get messy if they've gone wrong, and usually it's just nice to have something in there that's contractually binding, so that both sides agree that even if everything ends up a mess, we'll walk away and we won't speak ill of each other. And that's not an unusual thing to ask for at all. So I know I've absolutely just whizzed through that last bit. So I will open up for questions. Let me just find the chat. Lucy, thank you.
I'm here joining as well. So yeah, if anyone's got any questions, I mean, I know that that was a fantastic presentation. You covered so much in it.
Thank you.
For this all. So no, I mean, I know it's such a hot topic, and obviously, as we said, the games industry, there are loads of freelancers. I mean, that I work part time at Women in Games, and other than that, I have my own company doing some other stuff for people as well, and these are really important, and particularly I imagine for the music side, as you said, because of it's where are those lines and things.
For sure. I think what I will say is, if for any freelancer working in the industry, it's probably worth investing in a standard set of your own terms and conditions that governs what you do, or you can put in front of any studio that you work with.
Yeah.
Now, larger studios might have their own set, but especially if you're working with independent developers, usually they probably won't. So it can become a bit of a battle of the forms thing, but usually the person who puts their piece of paper in front of the other person first will be the one that gets used. So if you are a freelancer in the industry, and you're working with multiple people, I'd say it's always worth investing in your own terms, and making sure that they're really tight, and you can use them again and again and again.
Yeah. I can imagine you get all sorts of people coming, and they drag something off the internet and try to kind of fit it in, and you're like, oh my god, what have you done?
But it can be frustrating. I'm talking about the do contract thing. I think it has the right intentions. It is put on online with the best intentions, but when people fiddle around and they tweak around with it, contracts and lawyers, we're in business for a reason, I guess, in terms of one word or one tweak to a contract can really mess everything up, and you might not realize it.
Yes.
And it doesn't matter if something's been said pre-contract, whatever is in writing and signed, that's what's going to take precedence. And it can be frustrating for people to hear and see that, but unfortunately that's the case.
Oh no, definitely. I can totally imagine it. Well, I mean, look, that was a fantastic talk, and I just look like our questions are quiet, but I think it's because you were so extensive in what you were talking. But I'm sure, people who are here, if they have questions, I'm sure they can always also message you guys through Twitter, and then obviously you are contactable through here. but it
course,
really
of course.
is so useful. I mean, you know, people are. I think it's quite a lot to absorb as well, isn't it? And kind of think
Definitely.
about.
I've definitely thrown a lot at people. So yeah, I mean, people listening, if you do have questions, please DM me on Twitter, send me an email. You know, I'm not going to charge for that. I don't have a clock that goes on. I'm always happy to answer questions. So if you do have
Oh,
any,
that's
please do reach
fantastic.
out.
Thank you, Tim. And it's so useful, honestly, for our community, because I know, as you said, there are loads of freelancers here, and you can see the chat. So thank you very much, and have a good
Thanks
rest of
very
your
much, Lucy.
evening as well.
No, well, my pleasure. Thanks so much for people for sticking around for it, and thanks for having me. And yeah, I really appreciate it.